Abuju maigan gije kandishnakas, maigan indudam, saging donjiba. Hello, my name is Lorena Fontaine. I'm Korean Anishinaabe from the Saging First Nation. I'm speaking to you from the Treaty 1 area, which is my home territory. This presentation on Indigenous language rights is for the students at the University of Ottawa in Politics of Language, Power, Identity, Canada, and the World. Language rights has been the focus of my research for approximately the past 15 years. And part of the reason I became interested in this area is very personal. My family has experienced language loss over the past 2 generations. My parents were both fluent speakers as well as grandparents on both sides. Because of their experience in the residential school system, the language transmission stopped during my parents' generation. The other reason is due to, the other reason why I became interested in this area is related to my experience working on residential school claims in early 2000. During this period, Indigenous peoples across the country were not only seeking compensation for sexual and physical abuse they experienced in the residential school system, they were also seeking redress for loss of language and culture. And I would say approximately 90% of the claims, the residential school claims, Indigenous peoples were seeking for some kind of compensation that would assist with the revitalization of Indigenous languages. They were very afraid that the language and culture had not been passed on to their children or their grandchildren, and were looking for opportunities to revitalize the languages in Indigenous communities. Unfortunately, loss of language and culture was not a significant part of any residential school claim. And in fact, very few lawyers working on residential school claims, they did not simply know what to do with this part of the claim. As a result of this experience, I started reflecting on language rights in general, but particularly started reflecting on the loss of language and culture within my family. I realized after some personal reflection that I also carried shame towards my cultural identity, but I didn't realize that my parents were actually afraid to pass on the language to my brother and sister and I. They were afraid that we would not do well in school, that we would not be able to get jobs. And I think there was also some psychological fear that something would happen to us if we spoke our language in public. I want to, part of my advocacy work in this area is to ensure that my daughter's generation has an opportunity to hear and learn their ancestral language and learn about their culture in our educational system. It's very important for young Indigenous children to learn about their language and culture in school in order to be proud of their Indigenous identity. In this talk, I will emphasize the right to transmit Indigenous languages through education. I will be examining the Indigenous Languages Act that was passed in 2019, and my goal is to provoke some thoughts on the use of legal traditions and intercustomary in law in examining the Indigenous Languages Act, but primarily in order to advance a right to language transmission through education. I'm just going to share my screen here. Prior to 2019, there was Section 35 of the Constitution Act of 1982, which recognized Aboriginal and treaty rights, but was silent on whether this included language rights. This changed in 2019 when Canada passed the Indigenous Languages Act. The legislation recognizes that Section 35 now includes rights related to Indigenous languages. This now means that Indigenous languages enjoy constitutional rights along with Canada's official languages, French and English. This is a step in the right direction. Unfortunately, the Indigenous Languages Act does not define or clarify the type of language rights that are recognized in the legislation, or the type of language rights that Indigenous peoples have. It also does not provide any enforceable language rights to Indigenous peoples, and there are no obligations placed on the federal and government. The Minister of Canadian Heritage may, however, enter into different types of agreements or arrangements with respect to Indigenous language rights with Indigenous governments, organizations, taking into account the circumstances and needs of Indigenous peoples. The federal government has emphasized, actively emphasizes this point when there are criticisms over the lack of defined rights in the legislation. The government maintains that Indigenous language rights will be defined on a nation-to-nation basis. As a result, there are now two different sets of constitutional language rights. The first are language rights that are enforceable in the Charter of Rights and Freedoms in sections 16 to 22. I will talk a bit about section 22 later in the talk. Number two, there are language rights that are not enforceable under section 35. And of course, these language rights are related to Indigenous language rights under section 35. There are also no funding guarantees to support Indigenous languages in critical areas such as education. Currently, Indigenous peoples are only able to access project dollars on a year-to-year basis. It's important to keep in mind that the purpose of the Indigenous Languages Act is to support the revitalization of Indigenous languages. In order to support the revitalization of Indigenous languages, immersion programs are key for language transmission. Although some northern communities, as well as communities in Nunavut, have more fluent speakers, all Indigenous communities are currently losing speakers on a day-to-day basis, and language transmission remains an issue for every Indigenous community. All Indigenous languages in Canada are currently endangered. Our reality is that we have an aging Indigenous speaking population, and language transmission is not occurring in the home for the most part. Until that changes, our educational system plays a critical role in language transmission. In Canada, there are over 50 distinct languages that comprise of over 90 dialects, 90 different Indigenous language dialects. Although these languages can be as different from each other as the languages of Europe, They are largely languages of relationship. The vitality and continuity of Indigenous languages in Canada are dependent on the people's ability to transmit the language to the younger generation. Historically, Indigenous women have played a central role in language transmission. It begins from the bonding period between a mother and a child, and then is carried on with the community, extended family, and relationships with elders. The transmission process of language and culture amongst family and community is an inalienable inherent right. Language transmission is also a responsibility because language is recognized as a sacred gift from the Creator. The late Harold Cardinal elaborates on Cree customary law, that which is given to the people, and the people's sacred gifts. In this case, Indigenous languages are deemed sacred according to Cree customary law because it is derived from the people's unique relationship they have with the Creator. It cannot be given away or extinguished because of the responsibility to protect it for future use. Language is also recognized as a sacred responsibility because of its connection to the land. Ojibwe Elder Ruth Norton, who is from my community, the Saugeen First Nation, elaborates on the connection between language and land. Quote, "Languages are spiritual, and because of this, our rights are entrenched in the law of the land. As our ancestors tell us, the Creator has given us the land that we live in, and with the land, we are given language," unquote. Elder Norton also explains that language and its connection to the land are crucial to the development of relationships among human beings, but also to the identity of Indigenous peoples. Language and land relationships can also be seen in, for instance, the multiple and different Indigenous languages and dialects in specific areas of Canada, within language families, and even amongst relations and communities. Indigenous languages evolved according to the people's relationship to the living environment. Indigenous land-based language practices also evolved in our communication protocols, integrating our teachings derived from our relationship to the living environment. When Europeans arrived in Canada, the protocols of communicating with Indigenous peoples in their languages were included in the official ways of doing business. The ceremonial structures during trade and treaty negotiations provided language exchanges with context and meaning. Brian Slattery, a constitutional expert, observes that, quote, usually involved that these language exchanges, quote, usually involved formal exchange of greetings, presents, ceremonial belts, statements of grievance or intent, and reciprocal oral promises. The negotiations were conducted in at least two and sometimes a number of languages, and so involved interpreters in important roles, unquote. John Burroughs, Indigenous law expert, argues that these are also included as sources of Indigenous law, and they are embedded within different historical protocols around communication, such as feasting practices, gifting, and pipe ceremonies. Therefore, Indigenous law and legal traditions must be included as principles from which Indigenous language rights are interpreted and recognized. According to Burroughs, the sui generis framework of Section 35 insists that Indigenous law and common law principles must jointly inform the standards of judgment for Indigenous rights in the areas such as language. Brian Slattery also points out that Canada is in the midst of a long process of decolonization and challenges us to, quote, broaden our conception of the sources of Canadian law and to recognize the diverse roles that Inuit, Indian, and Métis peoples have played in the formation of this country and its constitution. It suggests that Aboriginal people should be viewed as active participants in generating the basic norms that govern us, not as people on the fringes, helpless victims or recipients of constitutional handouts from the government or courts, but as contributors to the evolution of our Constitution and most fundamental laws, unquote. Slattery further argues that Indigenous language rights have constitutional status under Section 35 and fall under the umbrella of a generic right, since they are inextricably tied to the cultural identity of all Indigenous peoples. Moreover, the ability to transfer language to the next generation would qualify as a right to cultural integrity under a more contemporary application of Aboriginal rights. Slattery reasons even further that Aboriginal groups arguably have the constitutional right to use their ancestral language and the right to enjoy the educational and cultural institutions needed to maintain and development, unquote. Indigenous languages in educational and cultural institutions are an integral component of Indigenous language rights. Language is an integral feature of Indigenous peoples' ability to manifest, nurture, and transmit culture. In addition to Slattery's observations of Section 35, as well as John Burroughs, the Charter of Rights and Freedoms has some guidance to offer. Section 23 guarantees minority language educational rights to the French-speaking communities outside of Quebec, and to a lesser extent, English-speaking minorities in Quebec. The purpose of Section 23 was identified in the Mahay case of 1990. In 1982, Jean-Claude Mahay, Angeline Martel, and Paul Dubé from Edmonton were dissatisfied with the quality of French language schools provided by Alberta. In 1982, they submitted a proposal to the Minister of Education for a new French elementary school. The Minister of Education told them that it was not in their policy to make such arrangements, and so they suggested they try to do it through the Public School Board. The Public School Board rejected them. Mahay and others brought an action against Alberta for violating their right to a Francophone-run education system under Section 23 of the Charter. The Supreme Court found that the purpose of Section 23 is to address the adverse impacts of provincial efforts to suppress French language schools in minority French language communities, and that history reveals that Section 23 was designed to correct, on a national scale, the progressive erosion of minority official languages. The Supreme Court also indicated that the purpose of Section 23 is also to preserve and promote the two official languages of Canada and their respective cultures by ensuring each language flourishes as far as possible in provinces where it is not spoken by the minority population. It aims at achieving this goal by granting minority language educational rights to minority language parents throughout Canada. In conclusion, there is obviously a great deal more work to do on the Indigenous Languages Act, considering Indigenous law, intercustomary law, as well as Supreme Court decisions on minority language rights to education. Currently, the Indigenous Languages Act does not define Indigenous language rights in a way that are enforceable. And to ensure that Indigenous rights to language transmission is recognized as an enforceable constitutional right. I hope that this discussion provokes more discussions on the Indigenous Languages Act, but also, more importantly, to assist with the revitalization of Indigenous Languages Act, or Indigenous languages within education in schools across the country. Miigwech, and take care.